The Magistrates' Court is where all criminal cases are first heard and normally handles cases known as summary offences, but can also deal with more serious indictments, such as burglary and those involving drugs, which are known as either-way offences.
Inside the court building, there are a variety of means that can assist defendants or litigants in finding their way around. Upon entering the building, you are immediately confronted with the large screen reception, which is well placed to assist with any queries. There are also large signs situated around the waiting area that explains the layout of the courtroom to visitors and also what they may experience, depending on the reason for their visit. In the case of a defendant, upon arrival, they have to inform a court official, such as an usher, about the reason they are in court and are asked to remain in the waiting room. During this time, a list of cases to be heard during the course of the day will be displayed on a large notice board, and the defendant is also asked to let the solicitor representing them know that they have arrived. When the case is being considered, defendants are led to the courtroom by the usher in most cases.
There are a variety of different entities that are represented in the court layout. Specifically, at Exeter Magistrates' Court, the nucleus and main focus of the courtroom is the dock. The superiority of magistrates is reinforced by the requirement for all others to stand when the magistrates enter and leave the courtroom, as well as the fact that they are situated above everyone else. All lawyers and clients are on an equal platform seating, suggesting that they are all equal in the eyes of the law. Magistrates sit in criminal courts as panels of three. All three have equal decision-making powers, but only one, the chairman, will speak in court and preside over the proceedings. The two magistrates sitting either side are referred to as the wingers.
Furthermore, the clerk gives legal advice to the magistrates, who are not legally trained.
The conduct of the court, in the cases our virtual law firm observed, did not impair the ability of the defendant to contribute to proceedings. For example, the courtroom clerk explained all of the relevant details concisely and clearly to the defendant, and asked after each statement if they understood. The clerk explained the rule of law being applied to the case so as to aid the magistrates, who then delivered their verdict through the chairman. The only negative aspect of the courtroom that may inhibit a defendant's ability to contribute to proceedings is the structure of the dock. The structure of the dock may make the defendant feel separated due to the towering, reinforced glass that surrounds it. However, on balance, this is a requirement to protect the courtroom from violent defendants, and is therefore only used during violent indictments.
The clerk clarifies any misunderstandings that arise in the court situation, for example, if the defendant doesn't understand the question being asked of them. Thus, they have to uphold Article 6 of the Declaration of Human Rights, the right to a fair trial, so that the information provided can be used to reach a reasoned and balanced judgment. The Crown Prosecution Service, who represent the Crown, present the facts of the case to the magistrates and the courtroom at the beginning of the hearing. There is a clear and distinctive separation between the defence and the prosecution in the courtroom, and this separation may increase further, depending on the type of indictment. There is a close relationship between the defendant and the representative, who sits directly in front of them. This relationship would assist their chance of a fair trial, as it would enable the defendant to directly instruct the representative. The case that we were observing at court also involved a domestic violence protection officer, whose job was to relay the court's proceedings for the day back to the plaintiff because they weren't present, once again enforcing a fair trial. Ethically, each lawyer should provide competent representation to a client, shall act with reasonable diligence and promptness in representing a client, and should not accept representation in a matter unless it can be performed competently and to completion. A lawyer may be disciplined for failing to research the law, performing an investigation, advising a client on possible defences, or taking other necessary steps to provide competent representation. It can also be possible to ensure that a client has the best ethical representation by asking if they'd like to be represented by someone of the same ethnicity. For example, if someone requested a black solicitor to represent them, then the Black Solicitors Network or Society of Asian Lawyers for Asians could be asked to nominate a solicitor to represent the client. In this way, our VLF would ensure that the best ethical representation of our client is carried out.
For this exercise, we split up the work in an equal manner, with each subgroup answering a particular question. We used the notes that were made in our court visits to respond to the questions, so that they were focused and accurate. We all found it to be an interesting experience as we saw how the law is applied in practice firsthand, and the measures taken by the court to ensure a fair trial.